My name is Allison Poirier. I also practice law at Kahan Kerensky Capossela in Vernon, as well as our office in Mansfield. I currently live in Huron with my husband and my 2 kids. Initially, I said I'd never wanted to become a lawyer because I love my father very much, but he was a lawyer, and I kind of said I want to forge my own path. So lo and behold, the very first job I got out of college was a paralegal, and I decided I liked it enough to actually become a lawyer and actually do the exact same type of law that my dad does. So you can say my father was my inspiration. Most people tend to think estate planning is simply just a will, which a will is the cornerstone to really most any estate plan. But estate planning also means there are some individuals who need a little bit more than a will, so sometimes a trust is appropriate. For example, if they're leaving money to minor children or financially irresponsible beneficiaries, or beneficiaries that are receiving some kind of state or federal assistance benefits like Medicaid. And then estate planning also comprises not only documents that'll assist your family or direct the passage of your assets after you pass away, but also includes planning for incapacity. So a good estate planning has not only a will, but also a power of attorney, healthcare directive, a living will, documents that are really going to help your family and your loved ones assist you when you need it. There is quite a big difference in between a will and a living will. A will's purpose is to direct the passage of your assets after you pass away, so who's going to receive your things. A living will sets forth your instructions as to what type of medical care you want to receive or not, that you don't want to receive at end of life. So specifically, the standard language that we use in most all of our living wills state that if you're at essentially end of life and there's little chance of recovery, that you don't wish extraordinary measures to be taken to save your life. And by extraordinary measures, that usually means artificial means of hydration or nutrition, so no feeding tubes, also no ventilators, CPR, and those sorts of things. Do your own wills are recognized. While you are free to do your own, there are still statutory requirements for what a will has to have in order for it to be considered valid. The big one being it has to be signed in the presence of 2 witnesses. So one of the biggest issues I see with clients that ultimately decide to do their own wills is that they go online and they print off a will and they sign it and they don't get the witnesses. Or they print it off and then they never even sign it. So it's just there are still formalities that need to be abided by. One of the documents that we do as part of an estate planning is a healthcare directive and living will, which the healthcare directive appoints who you want your medical decision maker to be if you can't make decisions for yourself. And the living will, as I mentioned, kind of describes what type of treatment you don't want to receive at the end of your life. The DNR is a document that can only be prepared by a physician. So that's nothing that an attorney can prepare in advance. It can only be prepared by the doctor after a conversation with them, which talks about the same things that a living will does. The doctor will ask what type of treatment do you want or do not want to receive, but then that's something the doctor puts directly into your medical chart. So if a doctor comes into your room and you're having health issues, they look at that and they see that you've elected not to receive CPR, so they'll know right away that they're not going to do that. Whereas the living will, the document that we would prepare on the legal side of things, to some extent just puts the doctors on notice as to the type of care you don't want to receive, but when the time comes to decide whether or not they're going to administer that care, they talk to your healthcare representative or your substitute medical decision maker and make them decide what they should or should not do. The only age requirement that exists in Connecticut to make a will is you have to be 18. So long as you're of 18 and sound mind, you can sign a will. There are certain life triggers where we recommend coming in and preparing a will, or if you already have an existing will, coming in and updating the will. The big ones are births, deaths, marriages, and divorces. So if you get divorced, a child gets divorced, or somebody's getting married, your new children or grandchildren are born, somebody who you've named to be a beneficiary or executor passes away, all of those types of things should trigger you to look at your will and powers of attorney and other estate planning documents and likely come in and update them as needed. One of the common statements that I hear from a lot of people is that, oh, I already have a will, so that means I don't need to go through probate. And that's essentially the reverse of the purpose that a will is supposed to serve. So if you have a will, your will provides the instructions for where your assets are going to pass. But those instructions can only be implemented by the probate court. So if you have a will, the sole purpose of the will is to go through probate and then provide, again, instructions as to where the court is directing your assets to pass ultimately. There are taxes for estates. The good news is it doesn't apply to over 99% of estates, just because you have to hit a certain asset threshold before the tax will apply to you. This year in Connecticut, the asset threshold you have to hit is $3.6 million. Most people I know of don't hit that asset threshold, myself included. So there is no estate tax that's paid. Also, the one question that I find is very common when people are concerned about taxes is the estate tax return is not a recurring return, so it's not your annual income tax return you're filing every year in April. The estate tax return is only ever filed once. It is filed for every estate, even if you don't have $3.6 million, because the purpose of the return is to prove to the state that you don't have to pay the tax. So it's only ever filed once, and it's filed 6 months after you pass away by your executor. Trusts are not just for millionaires. Trusts are beneficial to a host of people with various situations. The most common one I see is even with couples that don't necessarily maybe have a lot of assets, but they do have younger children. So should something happen to them while the children are still minors, the children wouldn't be able to inherit money anyways, because you have to be at least 18 years old to inherit. If you don't have a trust and your will just says, I leave everything to my children and they're young, somebody will be appointed by the court to manage the assets for the children. Then when the children turn 18, they will just get a very large check. So some parents are uncomfortable with the notion that an 18-year-old is going to inherit a decent amount of money. So instead they opt for a trust, which will appoint, specifically allows the parents to choose who they want to be in charge of managing the assets for the children while they're still younger. And it also gets to let the parents choose the age at which they want their children to inherit the money. So if they feel more comfortable with the kids inheriting at age 21 or 25 or 30, it really gives them more control as to when they want their children to actually receive the assets. One of the other primary reasons I see people motivated to leave somebody's inheritance in a trust is when their intended beneficiary is not overly responsible with money. So someone who they think is maybe a grown adult but just really not good with their finances. Leaving the money in the trust allows the money to be there for their benefit and for their use, but it puts kind of a gatekeeper in between them and the money. So you still appoint someone else to assist them in managing the money and ensuring it's there for them for really the length of time you intend it to be there for them. Whenever you have a beneficiary, whether it be a child or other family member who has some kind of disability and is likely receiving state or federal benefits, a lot of people think that you can't leave them anything, just because if they do, they'll either become ineligible to continue to receive those benefits, or it's all just going to go straight to the state. So, but there is a technique that is available for loved ones who want to leave members of their family with a disability an inheritance, and it's called a special needs trust, or it's sometimes also called a supplemental care trust. And the purpose of it is to hold that money for the beneficiary, so it's there for their use. But the money in that trust can only be used for specific purposes. And the reason why we limit what the money can be used for is to make sure that individual maintains their eligibility for the various benefit programs that they may be on. So the common restrictions are that the money in the trust can't be used to pay the beneficiary's medical care or shelter or lodging, food costs, because those are generally the services or the benefits they are getting through these state and federal benefit programs. So we don't want the money to be used for those purposes because that could jeopardize their continued eligibility. But we do say it can be used for pretty much anything above and beyond what their benefits programs cover. So it can be used for sometimes buying a car, it can be used for weekend trips, to buy clothing, to go to the movies, really all the things that the benefit programs don't cover. Estate planning documents never expire. That's the good news. Our general recommendation is every 4 to 5 years to pull your documents out and read through them, just so if nothing else, make sure they're still accurate, because that's enough amount of time where things might have changed. Documents never expire, they're always good, but periodic updates are definitely a good idea. So there's this very common belief that when somebody dies, the will's read. We see it a lot in the Hollywood movies that when somebody passes away, everybody sits around the table at the lawyer's office and they read the will out loud. So that's not a legal requirement. That's not something that has to be done. And I think its origins actually go back to the days when people didn't know how to read. So they all went into the lawyer's office and the lawyer would read it to them. So that way everybody kind of understood what was happening. The only requirement for who gets notice of the will or a copy of it or finds out what's in it is the people that are named in the will as beneficiaries, or what we call the heirs at law. So really next of kin. If you're married and you have children, even if they're not named in the will, your spouse and your children are obligated to receive a copy of the will. And when that happens is when the will is actually submitted to the probate court. in the scenario where the surviving spouse is the only one with a copy of the will, when she submits that will to the probate court, she's going to submit it to the court, but then she's then also required to send copies to the children, even if they're not her own, but if they were her husband's children, they're required by law to get a copy of the will as well. So there doesn't have to be a formal reading of the will, but at the end of the day, everyone will get a copy of it for themselves.